Thank you, everyone, for joining us today. I'm Eleni Caceres, and I'm a partner in the Vancouver office of Dentons Canada. I'm practice group leader for the Employment and Labor Group in British Columbia, and I will be moderating your session today. Today, I'm joined by three of my partners out of Toronto. First, we have Adam Goodman. He's one of our expert litigators in the Dentons Competition and Foreign Investment Review Group. We have Andy Pushalik, lead of our Employment and Labor Group, both nationally and in our Toronto office, and Sandy Walker. She is the co-chair of Dentons Competition and Foreign Investment Review Group and is also the chair of the executive committee of the National Competition Law section of the Canadian Bar Association. Today, we'll be hearing from Andy and Sandy on what employers need to know about amendments to Canada's Competition Act that will ban no-poach and wage-fixing agreements. And then we'll hear from Andy on the latest on non-competition and non-solicitation provisions generally, before we answer some of your questions at the end. I will turn it over to our panelists to tell you everything you need to know about the amendments to the Canada's Competition Act.
Thanks, Eleni. Can we go to the next slide? So in terms of the outline, today, Sandy and I are going to talk to you about no-poach and wage fixing. I'll start with an introduction to the Competition Act and some of the key concepts that are relevant to this area. Then Sandy will talk about wage fixing. I'll talk about no-poach, and then Sandy will finish off with some final comments. Next slide. And next slide. So the Competition Act is Canada's general antitrust statute. It's the federal statute that provides businesses with the rules that govern and regulate the promotion of competition in the economy. There are provisions in the Competition Act that render certain conduct criminal, means prohibited in all contexts, and then there are others that permit the Competition Bureau, or in some cases a private party that has leave, to challenge conduct on a civil basis. So criminal conduct is per se prohibited, punishable by prison sentences and fines, and private parties can sue for damages, and that includes through class action. As I mentioned before, civil reviewable conduct can be challenged by the Bureau or private parties with leave in the Competition Tribunal. Remedies under the civil provisions are injunctive in nature. So generally what that means is ultimately the Bureau or the private party challenging would get a prohibition order prohibiting the parties from continuing the conduct in the future. Administrative monetary penalties are also possible for abuse of dominance, but there are no damages that flow from civil reviewable conduct. Next slide, please. So criminal cartels are covered in Section 45 of the Competition Act. It's the key prohibition on this type of conduct, and it makes it a criminal offense for competitors to agree to fix prices, to allocate markets, or restrict output. These are things that our competition law deems to be wrong in all circumstances. And currently, Section 45 applies only to competing sellers, not to competing buyers. That will be amended, and that's the topic of today, to add a prohibition on wage fixing and no-poach. But as the law currently stands, it doesn't apply to competing buyers, but they will be brought in at least as it concerns wage fixing and no-poach. Next slide, please. So there are other key parts of Section 45 that are relevant. These are provisions that address the evidentiary challenge that the Crown has in proving that there's an agreement for the purpose of Section 45. And the reason for that is typically cartel conspiracies are not things that are open and clear on the face of a document. So there's a provision in Section 45 that permits a court to infer the existence of an agreement from circumstantial evidence. And there's also an important defense that's relevant for today's discussion for conduct that may on its face contravene Section 45, but is ancillary to a broader or separate agreement between the parties. And it provides that a court will not convict under Section 45 if the accused establishes that the conduct that is otherwise contrary to Section 45 is ancillary to a broader or separate agreement involving the same parties. The conduct is reasonably necessary to give effect to that broader or separate agreement, and that broader or separate agreement itself does not contravene Section 45. Next slide, please. So the civil reviewable conduct that's relevant in the no-poach and wage fixing context is Section 90.1, and it provides that the Competition Bureau, and only the Competition Bureau, can challenge any agreement between competitors on the basis of anti-competitive effects, a substantial lessening or prevention of competition in a market. So this applies to conduct that is not covered by Section 45. And today it covers no-poach and wage fixing. That will change on June 23rd, 2023, or 2023, because that is when the no-poach and wage fixing provisions come into force and it becomes criminally prohibited. But right now, Section 90.1 applies to wage fixing and no-poach. And the Bureau, the federal court, and the BC Supreme Court have all confirmed that the current version of Section 45 does not apply to agreements between employers concerning employees. Next slide. So we've reproduced the text here of the no-poach and wage fixing provision that will come into force on June 23rd. And it says, every person who is an employer commits an offense who, with another employer who is not affiliated with that person, conspires, agrees, or arranges, A, to fix, maintain, decrease, or control salaries, wages, or terms and conditions of employment, or B, to not solicit or hire each other's employees. And then you have in subsection 2 the provision that deals with punishment. And this essentially aligns the Canadian approach with the current US approach, which is to prosecute wage fixing and no-poach agreements criminally. And this subsection 1.1 is the focus of today's talk for Sandy and myself. Next slide, please. So where does this come from? So in 2010 in the United States, there was a no-poach arrangement between large tech firms in the United States that was prosecuted civilly by the US DOJ. And that's one of the first salvos in the recent history of no-poach and wage fixing. But that approach was revised in 2016 when the US agencies, the US DOJ and the FTC, issued guidance to HR professionals and essentially said that for these types of arrangements, the DOJ may prosecute them criminally going forward. And last year, in 2022, there were a series of trials of these criminally charged businesses, and the DOJ emerged with a mixed bag of results in terms of those prosecutions. In Canada, in 2020, the Bureau issued guidance saying that wage fixing and no-poach agreements were really outside the scope of Section 45, and that a remedy must be predicated on Section 90.1, which requires proof of anti-competitive effects, and for this type of conduct, all the Bureau would get would be a prohibition order, an injunction saying that the parties can't do this any longer on the basis of anti-competitive effects. In 2020, some of the large grocery chains in Canada around the same time canceled hero pay. There was some media attention to it, and that led, or all of these things led Parliament to enact the current subsection 1.1 to Section 45 in the Budget Implementation Act, and subsection 1.1 will come into force this summer, June 23rd. Next slide. So now I'm going to turn to the Competitor Collaboration Guidelines, which is the Competition Bureau's guidance regarding its approach to Section 45. And these were issued by the Bureau, who's our antitrust enforcement agency in Canada, who investigate these types of this type of conduct. And they issued the Competitor Collaboration Guidelines in 2009, before our current version of Section 45 came into force in 2010. And they really provide the framework of analysis that the Bureau uses to approach Section 45. And essentially what the main message in the Competitor Collaboration Guidelines is that not every potentially technical instance of Section 45 conduct, so price fixing, market allocation, or output restriction, would be treated as criminal. Remember, the Bureau can choose between the civil track, 90.1, based on anti-competitive effects and injunctive relief, or the criminal track under Section 45. And what the Bureau says in the Competitor Collaboration Guidelines is that they reserve Section 45 for agreements that cover the subject matter of Section 45, so price fixing, market allocation, or output restriction, but only in circumstances that constitute naked restraints on competition or hardcore cartel conduct. The Bureau says that other forms of competitor collaborations, like joint ventures, strategic alliances, those will be subject to review under the Act's civil provisions. So in order for the Bureau to look at something under Section 45, not only must the conduct be covered, but it really has to be a naked restraint on competition. So the purpose of the entire agreement is to enforce the price fixing, the market allocation, or the output restriction. And last month, so January 18, the Bureau released draft guidelines, particularly as it will approach wage fixing and no-poach going forward. And those are consistent with the Competitor Collaboration Guidelines. So next slide, please. So the draft guidelines have a consultation period that's still ongoing, and it's ongoing until next month. They reaffirm the framework under the Competitor Collaboration Guidelines. So what they say is that subsection 1.1 is directed at naked restraints on competition. That is, restraints on wages or job mobility that are not implemented in furtherance of a legitimate collaboration, strategic alliance, or joint venture. There's also other guidance in the guidelines on who the Bureau thinks is an employer. They also confirm that there's no application to affiliated employers. and they suggest that certain practices engaged in by employers, HR professionals, can be particularly risky after subsection 1.1 comes into force. I think that's it on this section. So with that, I will turn it over to the next slide and Sandy to address wage fixing.
Great, thank you, Adam. Next slide, please. So, as Adam has mentioned, the new provision prohibiting wage fixing comes into effect on June 23rd of this year. It prohibits wage fixing between employers. The penalties are jail for a maximum of 14 years or a fine in the discretion of the court, or both. As Adam has mentioned, the focus is on naked restraints. So this is basically the buy-side price fixing in the employment context. So the provision is directed at restraints on wages or job mobility that are not implemented in furtherance of a legitimate collaboration, strategic alliance, or joint venture. You'll see as we go through the slides that there is some question in the Bureau guidance, and it's draft guidance, I should say, that raises questions about whether it's focused enough on naked restraints, but we'll get to that in a few slides. Next slide, please. So let's unpack what wage fixing actually means. It's more broadly defined than just wages. It covers agreements or arrangements to fix, maintain, decrease, or control salaries or wages, but also terms and conditions of employment. And that could be quite broad. According to the Bureau's draft guidance, that could include things like benefits, policies such as job descriptions, allowances, non-monetary compensation, working hours, locations, and non-compete clauses. The Bureau's guidance indicates that it's going to interpret terms and conditions as those that could affect a person's decision to enter into or remain in an employment. So let's, next slide, please. And who does the prohibition apply to? The section applies to agreements between unaffiliated employers regarding their employees. Affiliation in the Competition Act is defined with reference to control, and that control might be, there can be upstream, downstream control, there can be affiliation laterally, and also downstream. What is an employer? It's not defined in the Competition Act, but the Competition Bureau's draft guidance says that it will look at a company's directors, officers, as well as agents or employees, such as human resource professionals. What is an employee? Well, that's going to depend on the laws of the jurisdiction and circumstances under which the relationship was entered into. So you may have a scenario where you have an independent contractor, but I think there's some case law on that Andy would know a lot more about than I would. But in some instances, independent contractors may actually be seen to be employees. As Adam noted, the employers do not need to be business competitors for the prohibition to apply. This is in contrast to the general provisions of Section 45. However, the Bureau indicates that it will prioritize enforcement of agreements where the employers can be seen as competitors in their purchase of labor. Next slide, please. As Adam noted, the ancillary restraints defense applies if there is a restraint that is ancillary to a broader agreement and is directly related to and reasonably necessary to give effect to the broader agreement, and the broader agreement is not itself a criminal conspiracy. So we've got a number of hypotheticals we thought would be useful to discuss. So the first one relates to, you've got parties to an M&A transaction. They've included an interim covenant, so a covenant that applies prior to closing, whereby the parties agree that the target will not increase compensation to certain employees. So would this be viewed as a violation of 45(1.1)? Well, the Bureau guidance is that it generally won't assess wage fixing clauses that are ancillary to merger transactions under the criminal track. However, it also says that it may do so if those clauses are clearly broader than necessary in terms of covered employees, territories, or duration, or where the merger is itself a sham. Now, I haven't run across many mergers that are a sham, so that part may not be that significant. But the fact that the Bureau might second guess, covered employees, territories, or duration, that scope, and might then treat that as criminal, is of concern. Because you may have merging parties, there's uncertainty about the reasonableness of some of these restraints under common law, and the contracting parties may in good faith enter an agreement that may subsequently found to be unenforceable at common law. But if the Bureau is looking at this and saying, well, in that instance, we might actually go after the merging parties criminally, that is of concern. Certainly our view is that the Bureau guidance should make clear that the restraints would really have to be egregiously overbroad before they're criminally prosecuted. But thus far, the draft guidance from the Bureau is that they will look at the reasonableness of the scope of these provisions. So we'll have to see if the final version of Bureau guidance remains the same. Next slide, please. So one of the topics that often comes up in the context of competitors is what happens if they exchange information, and sometimes this can occur through benchmarking. Information exchange by itself is not illegal under the Competition Act. However, a court can infer the existence of an agreement from circumstantial evidence, with or without direct evidence of communication between the parties. So consider a hypothetical. You've got human resource professionals from companies A, B, and C. They are each separately gathering market intelligence through hiring new recruits. And they're learning, some of the recruits may divulge that the salaries offered by the other companies. A, B, and C personnel are not discussing the salary levels with each other, but they do respond to what they hear from the recruits. Would that constitute a violation of 45(1.1)? Well, the Bureau offers some guidance on this in the draft guidance. The Bureau does not consider there to be a violation when a business acts independently with awareness of the likely response of its competitors or in response to the conduct of its competitors. So that this is what they call conscious parallelism. So the Bureau is saying they will not apply the prohibition in 1.1 to conscious parallelism. At the same time, the draft guidance says that parallel conduct, coupled with taking steps to monitor each other's employment practices, could be sufficient to prove an agreement. This raises some questions in my mind. It seems to me that they must be thinking of something more, because there has to be at least an inference of an agreement or understanding between A, B, and C. So this is another question, another area where the Bureau's guidance may need to be made a little bit more precise and clear. Next slide. Hypothetical, this hypothetical, we've got 3 law firms remaining in Toronto after the widespread introduction of ChatGPT, which is going to apparently make some of us obsolete. But we've got 3 law firms left. They're having difficulty coping with the bonus and work-life demands from their associates. They meet over lunch and they share detailed plans for bonuses for associates and return to work policies. Soon, their bonuses and return to work requirements are aligned. Unfortunately for them, they've got someone who studied competition law at law school, and that associate complains to the Competition Bureau. Is that a violation? Well, the Bureau might investigate in this scenario. Bonuses and RTW policies may influence an employee's decision to remain with the law firm. So what does the Bureau guidance say? Parallel conduct coupled with facilitating practices such as sharing sensitive employment information may be sufficient to prove that an agreement was concluded. And this is under the provision that relates to conduct can result in an inference by the Bureau of an agreement. In this case, the alignment of the 3 law firms' bonus and work policies after their meeting might well give rise to an inference that the law firms have come to an agreement. Next slide, please. This final scenario deals with information exchange by members of an association. So there are 100+ members. Each member provides salary data to the Widget Manufacturers Association, which then aggregates the information and sends each member a report of average salaries for different categories of employment. And it also includes the individual member's salary. Is that a violation? Well, in this scenario, the employers who are receiving the information, they do not know what any other individual employer is paying because the information is aggregated. So in this type of scenario, assuming the WMA has taken steps to safeguard the individual salary information, there shouldn't be an issue. However, if the members directly exchanged the same information with each other, in other words, their individual pay scales, etc., that would be a much riskier scenario. Next slide, please. So, question, the provision comes into effect in June. How are existing agreements that may relate to agreements on wages and terms and conditions of employment treated? Well, the Bureau has said it applies to new agreements and to conduct that reaffirms or implements older agreements. So what does that mean? Well, it suggests that you have to do something active. But this could include a failure to communicate the illegality of existing wage fixing agreements or a failure to amend existing contracts, if those could lead to the reaffirmation or implementation of existing provisions. For example, you might have an employee who's unaware that this agreement is no longer live and might attempt to enforce it. Because there's some vagueness about how the Bureau has worded it, we are looking for better Bureau guidance on this point. Next slide, please. So there are a couple of additional exceptions or defenses to the wage fixing provision. Section 4 of the Competition Act is still applicable. That's a provision not many people are that familiar with, but it basically immunizes agreements reached between employers in the course of collective bargaining. I won't read the whole provision out, but it does protect such agreements. The other defense that will continue to be available is the common law defense, regulated conduct defense, and that applies where there's an agreement a requirement or authorization by or under a federal or provincial law to engage in certain conduct. And I think I'm ready to hand it back to you, Adam.
Thanks, Sandy. So I will now turn to no-poach. Next slide, please. So no-poach agreements are covered by paragraph 45 1.1b, and this paragraph provides that unaffiliated employers are prohibited from agreeing not to solicit or hire each other's employees, and there does not need to be a competitor relationship between the employers. All they need to be is employers. The Bureau has confirmed in its draft guidelines that the term solicit and hiring includes, in their view, any limitation on hiring opportunities. Now, the Bureau's interpretation goes further than the actual wording of the provision. The guidance says, or the draft guidance says, that restricting communication of job openings may be covered. Adopting hiring mechanisms to prevent employees from being poached or hired by another party to a conspiracy may be covered. The Bureau also talks in the draft guidance about alignment on hiring mechanisms or using point systems. Not necessarily clear what the Bureau has in mind here, but it appears to concern the implementation of an existing agreement not to poach each other's or solicit each other's employees, ways of monitoring that type of an arrangement. So there's still quite a bit of ambiguity in the guidance, but there's also some welcome comments from the Bureau that confirms that paragraph B applies only to bilateral agreements. So the Bureau says that based on the wording of paragraph B, they consider it applies only to agreements between employers not to solicit or hire each other's employees, and that doesn't apply to unilateral agreements where only one side agrees not to hire the other side's employees. So if a bilateral, but that does not necessarily complete the picture, because if there's another agreement where the other employer agrees not to solicit or hire the other side's employers, they'll look at those two agreements together. So you need to take a global approach to the relationship between the employers. Next slide, please. So as it concerns naked restraints or ancillary restraints in the no-poach context, the guidance does say that it can be common for no-poach provisions to be included in typical commercial arrangements. So joint ventures, M&A, purchase and sale of a business, consulting arrangements, internship or secondment arrangements. That's somewhere where we're aware that they pop up. In terms of the analysis, the Bureau's guidance suggests that we need to ask two questions. The first question is the restraint bilateral or unilateral? If the restraint is unilateral, Section 45 does not apply. If it's bilateral, we need to consider whether this is a naked restraint or an ancillary restraint. So that's the second question. So then we go into the analysis under the ancillary restraints defense. Is there a separate and broader agreement between the parties? Is the restraint directly related to reasonably necessary to achieve the objective of the separate or broader agreement? And does that separate broader agreement violate Section 45? Next slide, please. And the Bureau's approach to ancillary restraint says, and I think Sandy covered this as well, the Bureau says, look, we're not going to second guess parties and ask whether less restrictive means are available to achieve the objective. But the problem is the draft guidelines then go on to say essentially that they are going to second guess whether less restrictive means were available. And that's in section 3.1 of the draft guidelines. So what employers need to be careful about is the same thing that you would worry about in terms of enforceability. Is the territorial scope or duration too long or too broad? Previously, that kind of analysis would inform whether or not you could enforce the restriction. Now the Bureau is saying that could suggest illegality under Section 45. The implications are that employers need to seriously consider whether bilateral no-poach provisions are commercially reasonable to achieve a legitimate commercial outcome. And we can't simply rest on trying to, push the envelope to achieve the best HR outcome, because the outcome is not necessarily that it will only be too broad to be enforceable. Again, it could suggest illegality, at least in the Bureau's view at this point. So everyone on the call needs to think about whether the parties in any particular agreement need or want the provision at issue. Next slide, please. So with that, I'll turn to some of the hypothetical scenarios that are in the Bureau's draft guidelines at present. So the first is a scenario that deals with employee secondment. And in this hypothetical, there's company A, that's a consulting company. It embeds employees in its clients' businesses for a set period. It enters into an agreement with company B. B covenants not to hire A's employees. Company A does not make a similar covenant regarding B's employees. Now, this is pretty easy given the Bureau's guidance. Because this is unilateral, it's not covered by paragraph B. The harder question, and this is not in the guidance, is what if company A made a similar covenant? So if there was a bilateral covenant for these parties not to hire each other's employees, you need to move on to the question and the analysis on why is this provision necessary? And frankly, there may be rationales, including if A's employees are being exposed to B's employees within company B's workspace, they may be in a position to assess employees and gain otherwise confidential information about company B's approach to its employees that would give it an unfair advantage. And having embedded employees exposes company B to the risk that information about its employees would be exposed to competing employers. So there, at least in the hypothetical scenario, under the naked restraints guidance, there can be rationales on why you would want or why the parties would want bilateral no-poach provisions in consulting agreements. Next slide. So in another hypothetical scenario in the Bureau's draft guidance, it covers a staffing company X that provides staffing and recruitment services. It enters into an agreement with company Y regarding staffing, providing specialized employees for a short period. They agree not to hire each other's employees during the term of the agreement. The Bureau indicates that although this is covered by paragraph B, the agreement can qualify as ancillary, and that's similar to the hypothetical scenario that I just went into, where an otherwise unilateral scenario moves to bilateral. But the Bureau does warn that it will assess whether this restriction is too broad. So the geographic scope, duration, seems here the duration in the Bureau's view is reasonable given it's limited to the term of the agreement. Next slide, please. So in this scenario, it deals with no-poach arrangements in the franchise context, and company A is the franchisor of fast food restaurants. Company A and its franchisees spend money to train new employees. Company A and each of its franchisees agree not to hire each other's current employees, and franchisees understand other franchisees are similarly prohibited under their agreements with Company A. So the Bureau says that each agreement between Company A and its franchisees needs to be assessed individually to see if they qualify as ancillary. And the Bureau doesn't think that franchisees can benefit from the ancillary restraints defense. And that suggests that the Bureau may be aggressive in the franchise context. And that's consistent with the interest that these restrictions have raised in other jurisdictions, including the United States, in particularly the fast food context, and enforcement agencies there questioning whether these no-poach arrangements are reasonably necessary for the franchise context in those scenarios. So with that, I will pass the baton back to Sandy for some concluding thoughts on no-poach and wage fixing.
Thanks, Adam. Next two slides. If you could go two more slides. This one, that's great. Back one, sorry. That's great. I know we are running a little late, so I'm going to just quickly remark that because there's now this wage fixing no poach prohibition, merging parties need to consider the extent to which they can share detailed information relating to salaries, wages, terms and conditions of employment in the pre-closing period. There could be an inference of an agreement on those matters if the sale doesn't proceed, for example. However, the ancillary restraints defense may well apply. Parties need to look at whether it's reasonably necessary to share that information. Next slide, please. So this is the final question is, well, where do you go from here? So Adam and I are suggesting some next steps to ensure compliance with 45.1.1. Review your agreements, or you may have categories of agreements that are all the same. Ask whether they contain the prohibited clauses. In terms of no poach, a key question is, are they bilateral? Are they unilateral? If unilateral, they would not be covered by the new prohibition. Ask whether the ancillaries defense may apply. In other words, is this a commercially reasonable restriction pursuant to a broader or separate agreement? does the regulated conduct defense apply? If the decision is made that these clauses are risky, amend the agreements to eliminate the offending clauses, communicate to employees that the agreements have been amended or will be amended to no longer include those provisions. And even if you haven't got around to not deleting the offending provision, you really need to have a good communication strategy to ensure that employees are not enforcing those clauses or threatening to enforce them. And with that, I'll conclude our part and hand it over to Andy.
Great. Thanks, Sandy and Adam, and really appreciate our colleagues from our competition group for joining, because I've been getting a lot of questions on this, and I know there's a number of questions in the chat. So we're going to speed right on, and very brief update on non-competition clauses and non-solicitation provisions. So if you go to the next slide, the bottom line, and as you've been reading in the news, the newest endangered species in employment law is a non-competition clause. Ontario introduced legislation last year that banned non-competes in employment agreements. There are exceptions, of course, sales and leases of business, certain levels of executives, non-competes that were entered into before October 25th, 2021. Those are all okay, as are non-solicitation and non-disclosure agreements for now. What you'll have seen in the US is that the FTC proposed a rule that would amount to an almost complete ban on the use of non-compete agreements. And then very recently, there's now a discussion about whether non-disclosure agreements in particular types of cases should be included. One of those areas is cases involving sexual harassment. Prince Edward Island has passed a law banning non-disclosure agreements in those contexts. Of course, there are some carve-outs. And then recently, there's been a similar move again in the US through the FTC with a proposed rule. So something to keep an eye on. So when we're looking at this, what can we do? And if you look at the next slide, I'm citing a case. It's from a while ago from British Columbia, and it's called Rayburg and Creston Veterinary Clinic. And what happened in that case, it's a veterinary clinic in a place called Creston, BC. They did specialization in dairy cows. And so there's really no clinics nearby in terms of nothing within a 100-mile radius, except for 2 that are across the American border. And then there's 13 clinics, but they're within a 130-mile radius. So the principals of this veterinarian clinic, they hired a newly graduated veterinarian on a 3-year contract. And what the non-compete clause provided was that it didn't necessarily prevent the new doctor from competing with this veterinarian clinic. What it did is it said that if at the termination of this contract, the doctor sets up a veterinary practice. So that's going to become important later. You can see the clause here on the slide, sets up a veterinary practice in Creston, BC, or within a 25-mile radius in British Columbia of where the clinic's located. Then that doctor has to pay a certain amount depending on when the clinic has been set up. So within 1 year, it's $150,000, 2 years, $120,000, and 3 years, $90,000. So if you go to the next slide, what the doctors who owned the clinic had done is they had viewed that amount that had to be paid as a representation of how much money it would cost to mentor, train, get equipment for a replacement. So in this case, what happens is the newly hired doctor leaves after 14 months, and she actually brings an application to the court to say, I'm going to set up a mobile clinic that may be operating in Creston and the vicinity, and I want to make sure that that non-compete clause is not enforceable. If you go to the next slide, you can see what happens. And the trial judge says, this is a non-compete. You can dress it up however you want, but it's a restraint on trade. And I think it's unreasonable because those amounts that doctor has to pay, they're actually a penalty. And because of that, this is an unreasonable clause, and therefore it's not enforceable. The clinic appealed, and the big outcome is, at the end of the day, the appeal is dismissed. But there's some really important takeaways here, because what the Court of Appeal says is that I agree with the trial judge, this is a restraint of trade. but they disagreed based on some Ontario case law that the amounts that were contemplated were actually penalties. They disagreed with that. They thought that they were not penalties, and that effectively what this was a pay to play. If you wanted to compete, you could do it, but you actually had to pay these amounts. Where the Court of Appeal finally came down, though, in terms of dismissing the appeal and upholding the decision for the doctor, was that the idea of what set up a veterinarian practice, that had a variety of meanings. And you can see the rationale on the next slide with the quote that we've produced. The uncertainty lies in there being no prescribed or understood basis upon which it can be said a professional practice has been established in the circumstances. Once it's accepted, Dr. Ribbergen can engage in some measure of practice, however limited, without incurring liability of the clinic. It cannot be said how many animals or on how many occasions, with what frequency, for how long, and over what period of time she could render the treatment before she would have crossed the line, so to speak, and become liable to pay the clinic $150,000 because a practice had been set up. The phrase set up a veterinarian practice is simply not definitive. The meaning is not clear and it renders the clause ambiguous. So just some quick takeaways. And I expected that the bulk of the presentation, we expected that it would be devoted to the Competition Act amendment. So we did nonetheless want to give you a bit of a case law flavor and what was going to be happening next. So if you go to the next slide, where do we go from here? Obviously, greater scrutiny for non-competition agreements, and we're going to get to your questions in a minute about the no-poach and no wage fixing agreements. But there may be an opportunity for employers to rely on clauses that put a price on competition, so long as they are drafted narrowly and clearly. Because again, the BC Court of Appeal didn't say that that clause was unenforceable simply because it was putting a price on competition. What it ultimately did is it said, we just don't know what that means when it says set up a veterinarian practice. So you can work with your Dentons lawyers to figure out what the best way to describe competitive activity. You may be able to find yourself in a more enforceable situation, notwithstanding the changing landscape. Otherwise, greater reliance on non-solicitation clauses for sure. And the last one is you may want to be considering for some of your executives that may not qualify for the exemption in Ontario or otherwise, a longer resignation notice period. Now, of course, it's not going to be a 2-year resignation notice period, but you may start to see things where employers are insisting on 3 to 6 months. And there is case law where a case in Ontario involving BlackBerry, where the company actually pursued an executive who tried to resign with less than the notice required in the contract, and the company was successful. So the courts will uphold those. So just a very quick flavor of what's happening in this area, but I'm going to turn it back to Eleni, and hopefully we can squeeze in a few questions before we hit to the top of the hour.
Thanks, Andy. Yeah, we do have quite a bit of interest here on this topic as we anticipated. I think I'll just turn it over to the panel to answer a couple of these. I have one relating to agreements. In relation to reasonably necessary as an ancillary restraint, has the Bureau provided guidance on what that may include? For example, on the face of it, most joint venture agreements could function without including a no-poach clause. What makes a no-poach clause reasonably necessary?
I'll just jump in, shall I? Okay, so it has to be reasonably related to or directly related to or reasonably necessary to achieve the goals of the broader agreement. So if it isn't actually, one is if it's unilateral, it'll be okay, but if it's bilateral, then if it's not really necessary for the purposes of the JV, it could run afoul of 1.1. So the Bureau generally on ancillary restraints, the guidance, what the draft guidance says, they're going to look at the subject matter of the restraint, the duration, the geographic scope. So those are sort of some basics.
Great, thanks, Sandy. Another question here, maybe Adam, you can speak quickly on it as opposed to diving into the full US case law, but Can we derive any principles from the 2022 US cases as to how the provision is likely to be enforced and what behavior will run afoul of the provision and what defenses were successful?
So it's a good question. I think what we can take from that, this will depend on the Bureau's appetite, but I think what we can take from those cases is that the U.S. agencies and the U.S. DOJ was very aggressive in pursuing cases. It was not able to obtain all the convictions it wanted. In fact, most of the convictions it wanted, and at least in one of the cases, it failed to obtain a conviction on the conduct at issue, and only got a conviction on obstruction charges in terms of I think it was tampering with evidence after the investigation. But in terms of what we can take from what happened, and we're kind of limited because these were jury trials, but it does seem that in terms of the instruction that the judges gave, that the U.S. approach will be similar to the approach, or most of the approach, that we anticipate the Bureau will ultimately land on, which is that this conduct really becomes illegal if it's if it's a naked restraint on competition, where the purpose of the agreement is to enforce the no-poach or wage fixing, which is actually that's a more helpful position than what the Bureau currently has, because what the Bureau currently has in its draft guidance is you need to qualify for the ancillary restraints defense, and if you qualify for that, then we'll consider it to be a naked restraint. And what I think the U.S. court suggests, and where hopefully we would get to, is that there is no actual second guessing of what's reasonable in the circumstances. The real question is, does this restraint arise in the context of a legitimate broader agreement? Yes or no? And if the answer is yes, then should not be looked at as a 45 violation.
Great, thanks. I think we'll do one more. Sorry that we're not going to be able to answer all the questions today, but Adam, Sandy, our employment agreements usually talk about restrictions on solicitation. You can't hire employees if you leave employment. And we have a great question about, if in the next phase of your life you're to be considered an employer, should we be amending our non-solicitation agreements with employees so as to remove prohibitions of the employees hiring or employing, which is part of our normal language in those agreements, versus simply saying you can't solicit them to, end their agreement, for example, with the current employer. Should we be looking at the employment agreements to remove references that could be considered that the employee, when they leave employment, would become an employer for the purposes of the Competition Act?
So just briefly, I will say that we at least need to think about that. Okay. Well, great. Thanks for that. I think this topic has given us a lot to think about. Andy, you turned your video on. Do you want to weigh in on this one?
No, I didn't know if Sandy had something to say. The only thing I am always wary of no hire provisions. There's not much case law on them, and so I generally say that you can certainly have a no solicit. The no hire, I think, becomes potentially a bit more tricky, but against this backdrop, I think you're just going to have more and more scrutiny. But again, very limited case law on it, so it's something, as Adam said, you'd probably want more consideration before providing a definitive answer.
Right. Well, with that, I just want to thank everyone for attending today, and thank our speakers for all their great information that they were able to provide. We hope that everyone on the call found the session valuable. Our next webinar is taking place on March 31st, so look for the invitation in the coming weeks. And thanks again for everyone for attending, and have a great weekend.